Well, good morning, everybody. Here it is Friday, and we're going to all try to get an early start on the weekend. But this morning, we're going to talk about the Texas Payday Law. Now, to be perfectly honest, this law does not take between 9:45 and 11:15 to discuss. So you will probably get out of here a little bit early. But I know, I'm sorry. You can stay here, though, till 11:15. It's okay. I would encourage you to ask me questions as we go along. Don't wait for the end, because we do have plenty of time. Now, the other thing is I have not included slides on the appeals process under the Payday Law, but I may talk about that a little bit at the end. Most of you undoubtedly know it because they follow the same essential pattern as the unemployment appeals process, and I'm sure that anybody that's been around in this line of work for as long as some of us have done quite a few of those TWC appeals. All right. Yesterday, I talked about the Fair Labor Standards Act, which is the federal minimum wage and overtime law. And the FLSA, of course, has national reach. But the FLSA does not address a number of things. It does not address form of payment. It does not address timing of payment. It does not address, except under certain circumstances, wage deductions. It doesn't require consent for wage deductions. There's a lot of gaps in the FLSA. And these gaps have been filled on a kind of an ad hoc basis by state wage payment laws over the years. And the Texas wage payment law is the Payday Law. Now, there are lots of people who believe across the political spectrum. Some people think that everything ought to be federal. Other people think the Fed should stay out of everything and make it state by state. But almost all the payroll people I know would like at least one thing to be national in scope. They wish that the payday laws or the wage payment laws were consistent. A very simple example is payment of last paychecks. Here in Texas, as we'll see in a moment, it's next regular payday for a voluntary termination, 6 calendar days for an involuntary termination. Head west a little bit, get to Arizona, it's 3 days. Head a little further west and get to California, it's right now. So this is one of those things that's extremely frustrating to people, is the fact that if you're a multi-state employer, as many of you are, that the wage payment laws differ across the country, and especially when you're out of state and have to deal with California. I've had several retail clients that when somebody leaves, especially when they get fired, they figure out the deductions, etc., and pay them the net out of the cash register. Have them sign a receipt authorizing that, and then issue the paycheck, and of course zero it out because you've already advanced them the amount of the net. Others will suspend the person for a day while the last paycheck gets airmailed or gets FedExed to the establishment. So some of these payday laws can be a little strange, and I wish we had a uniform federal set of guidelines, but we don't. So for wage payment issues, it's a state-by-state basis, and all of you are just going to have to be familiar with those resources that can identify the various state wage payment laws. Okay, I think I told you yesterday, I don't know that all of you were here yesterday, but I think I told you that anybody that's attended one of my sessions, I have no problem with you following up for brief telephone consulting or email response. So that's my contact information. If any of you have a quick question, next week you suddenly think of something, don't hesitate to give me a call or shoot me an email. Okay, let's start with the concept of wages. What are wages subject to the Payday Law? According to the statute, wages includes all compensation for services rendered regardless of how they are computed. So an hourly rate, a salary, commissions and bonuses, and fringe benefits. Now let's talk about commissions and bonuses. And I'll talk a little bit more about this in the context of last paychecks. But basically, commissions and bonuses are payable according to the agreement between the parties. So if you pay employees piece rates or you're in an apartment complex and you pay them leasing bonuses, or whatever it may be. Whatever your preferably written agreement is what you have to follow. If you don't have a written agreement, then what's TWC going to look at if there's a dispute over wages? They're going to look at your pattern and practice. They're going to look at the course of dealings between the parties. Essentially, a commission is due or a bonus is due, and here I'm going to use a typical lawyer phrase, when all the conditions precedent, or precedent, some people pronounce it, are completed. So if according to our plan, your commission is due when the customer's check clears the bank, then that's when those commissions are due, not when you consummate the sale. On the other hand, if it's when the sale is consummated, then at that point the person has earned those wages and they're payable even if they subsequently quit or get fired. So whatever your plan, whatever your practice is, that's what determines whether and when commissions, bonuses, etc. are payable. And then certain fringe benefits due under a written agreement with the, or policy of the employer. TWC is big on written agreements. Okay. Draws against commissions or bonuses may be recovered from the current or any subsequent pay period until fully reconciled. So under the Payday Law, we talk about employees' consent. But this is one of those things that's not really considered to be a deduction, and so no consent is required. If your plan, let's say you pay commissions quarterly, but your employees get an advance every week, every 2 weeks, twice a month, they get draws or advances against earned commissions, and then at the end of that quarter, you do a reconciliation. So let's say the quarterly bonus is $7,000, and you've advanced them $6,800, then of course you pay them the extra $200. But what this is saying is if at the end of that quarter you've advanced them $6,800 and they've only earned $6,700, then you can recover that $100 from subsequent commission checks, from subsequent paychecks until it's fully reconciled. So you can always get back advances of commission, draws against commissions, etc. Okay, whoops. How are wages to be paid? The U.S. Department of Labor does not say anything about how wages are to be paid. So the Texas Payday Law fills that gap as follows. You can give them to them in person. You can mail them to a designated address. And notice this, in time to be received on the payday. I actually had a big client get threatened with having to, and this is a company that's religious about compliance with stuff, but they were threatened by TWC with some fines, some penalties, and with having to post a wage payment bond because for some reason or another, there had been a series of complaints from employees who said that their wages that had been mailed to them were late. So this can turn into a big deal. If paychecks are due on the 15th and you drop them in the mail on the 14th, you got a problem because they may not get there on the 15th, and if TWC gets enough complaints about that, they're going to be upset. So if you're one of those employers that gins out the checks on payday and hands them to some but mails them to others, you're technically in violation of the Payday Law because, obviously you're mailing them on payday and they're going to get there later than payday. So it's important to give yourself some time. I know that a lot of companies pay up to date. So if payday's the 15th, you get a check for the period ending the 15th on the 15th. I have never thought that's a good idea. Always give yourself a gap, a lag between the end of the pay period and your designated payday. So you have time to account for all of the hours, so you have time to account for any problems, and so you have time to get the check into the hands of the employees on payday or before payday. Okay, you may use direct deposit into an account. You may give it to a third party who has been authorized by the employee in writing to receive the employee's paycheck. So, If we have one of those marriages where one spouse does the earning and the other spouse gets the check, then the earning spouse can give an authorization that the check is to be delivered to my husband or my wife. And that's perfectly permissible, but obviously that's something you want to get in writing, or any other way the employee has agreed to in writing. So, delivery of wages is pretty broad in Texas. You must designate paydays in the state of Texas. Now, I know that seems basic, but it is a requirement of the statute. You have to actually designate the payday, and you must post notices of paydays in conspicuous places in the workplace. Well, where do you put these? You put them along with every other blessed poster you have to put up next to the time clock, preferably. If not in the break room, in some place where it's conspicuous and where employees congregate and can easily read and understand and ask questions about. Now, if you don't designate payday, this is one of those archaic things that's been around for 100 years. If you don't designate paydays, the employer's paydays are the 1st and the 15th. So, yes?
If it's biweekly, can it just say biweekly, or do you have to have an actual calendar of the date?
You are supposed to have a calendar. So you're supposed to say paydays are for the year. Yeah, you should do that. I don't think that's ever enforced. I mean, that's technically, if you posted biweekly and at the beginning of the year say the first payday is, January the 14th, then everybody else can do the math. All right. Now, how frequently must you pay wages? Actually, the Department of Labor, the FLSA says nothing about this. Department of Labor has in their field operations handbook a policy that says monthly for exempt employees, semi-monthly for non-exempt employees. But that's just an enforcement position, and there's no official statute in the federal law. There is in Texas. You got to pay and it's the same. You've got to pay FLSA exempt employees at least monthly, and FLSA non-exempt employees must be paid at least twice a month. How many of you have semi-monthly payrolls, 2 times a month? How many of you have biweekly? More biweekly. How many of you have weekly? Okay. Now you know that in some states, particularly in the Northeast for some reason, there is a requirement that you pay your employees weekly, or at least that you pay your non-exempt employees weekly. Various state laws. New York is weird. It says people who do manual labor have to be paid weekly, and other people don't have to be paid weekly. They can be paid biweekly or semi-monthly. So this is another one of those things that you need, if you're a multi-state employer, you need to be aware of the fact that state laws are going to vary. And some states are going to require that you pay at least your non-exempt employees week to week. Now, in a number of those states, the law allows you, with the consent of the employees, to pay less frequently. So that's not something that is often enforced, but it's there, and you should be aware of it. And then this is obvious, but semi-monthly pay periods must contain, as nearly as possible, an equal number of days. So you shouldn't have 10 days in the first pay period and 20 or 21 in the second pay period. Not that that's likely to happen. And obviously we know that in February we have fewer days in the second pay period, and in the 31-day months we're going to have more. But as nearly as possible, given the orbit of the Earth around the Sun, as nearly as possible, you should have an equal number of days. Okay. Now, in our panel yesterday, we talked about direct deposit, and Alexis actually gave you far more information than I'm going to give you. She ran briefly through a review of a number of states on direct deposit. I'm just going to talk a little bit about the FLSA, about the Federal Department of Labor, and about Texas. Employers under the Payday Law may elect to pay wages via direct deposit as long as the employer gives at least 60 days advance written notice of the adoption of the direct deposit wage payment system. So if you do not use it now, and you want to adopt a direct deposit system, then you got to give them at least 60 days to get this system cranked up and fired up and ready to go. So you may not implement it next payday. You must give them a run-up or warning period of time. And then you must obtain from the employees, I don't know why they say this, you must obtain from the employees whatever information is required by their banks to commence such a deposit. Well, of course, if you don't do that, you can't do direct deposit, but it's written into the statute. But the feds still say direct deposit cannot be mandatory, not as a statute, not as a regulation, but there's still a blurb in the Wage and Hour Field Operations Handbook, and I checked it this morning to be sure there had been no change. And it's the FOH still says employees must have, quote, the option of receiving payment by cash or check directly from the employer. So now, I have never in all my career seen the U.S. Department of Labor's Wage and Hour Division get involved in a question like this at all. I think it's one of those things, it's been in the Field Operations Handbook since 1981, it's been unchanged since 1981, and I think that probably it's just exists on paper and is not a real issue, but I ought to make you aware of it. All right, as an alternative, I said 81, it's 88. As an alternative to getting cash or a physical check, says the Department of Labor, the employer may make arrangements for employees to cash a check drawn against the employer's payroll deposit account if it is at a place convenient to their employment and without charge to them. So, this is intended to address the employee who doesn't have a bank account. So you write them a check, and you make arrangements that either your bank is close by, or branches are close by, or some other institution will cash their check without a charge to them. I had a client once that had it was a landscape company. They put out a bunch of checks to people, and they had made arrangements with the convenience store gas station just down the road to cash their paychecks for them at no charge. I think the employer gave the convenience store some fee for every check that was cashed. But the point is, those employees, had access to that store at all hours because it was a 24-hour store, and it didn't cost them anything. So even the employees who didn't have a checking account into which they could deposit the check were able to cash it. But Wage and Hour is still saying, and again, I don't know how often it's going to be enforced, but Wage and Hour is still saying that if they don't have a bank account or they don't want direct deposit, that you have to either give them a check, give them cash, or arrange that some institution will cash their check without charge. Okay, now, the FDIC says employers may not require a consumer to establish an account for receipt of electronic fund transfers with a particular financial institution as a condition of employment. Alexis mentioned this yesterday. You can require direct deposit with that exception that they have the right to ask for a particular, to ask for alternative payment. But you can't make them open a bank account at a particular financial institution. So you can't say, we'll do direct deposit, but it's got to be in Chase, or it's got to be Bank of America, or it's got to be some other bank. You have to give them the option of what institution, into which institution you will make the direct deposit. Okay, what about pay cards? This is something that Alexis mentioned yesterday. For some reason, the CFPB, a little background. The CFPB is that agency that was started after the crash. And remember, there was a huge fight in Congress because the president nominated Elizabeth Warren to be the first head of this Consumer Financial Protection Board. And the Republicans were so opposed to Elizabeth Warren that they refused to fund this agency. Finally, the president withdrew Elizabeth Warren's name, and a person named Richard Cordry was named as the head of this agency, so the agency is in business. And then Elizabeth Warren then ran for the Senate and won, and is now a senator from Massachusetts, and is talked about as a presidential candidate, though I'm not going to get into politics. But anyway, they said that employers cannot require their employees to receive wages on a payroll card. Now, I've never read anything about enforcement of that. I don't claim to be an expert in that area anyway, but there's nothing wrong with doing payroll cards, but this agency says it can't be a requirement. All right, deductions from wages. Yesterday, I talked about the Fair Labor Standards Act and what it says and doesn't say with regard to deductions. You will recall that essentially I distinguished between deductions that are not for the employer's benefit, such as advances of loans, such as purchases from the employer, including fringe benefits, and I said that the FLSA doesn't interfere with those. But I also pointed out that under the FLSA, deductions that are considered to be for the benefit of the employer are limited. Essentially, you may not make a deduction for the employer's benefit if it cuts into the minimum wage for up to the first 40 hours of the work week, and you may make no deduction that affects overtime hours. So what I was saying was, if I make $8.25 an hour, and the minimum wage is $7.25 an hour, I've made $1 an hour over minimum wage. In a 40-hour week, I've made $40 over minimum wage. The wage and hour law says that any deduction for the employer's benefit in that work week that would exceed the $40 over minimum that I made would be a violation. So does everybody understand that? I also said that if I worked 50 hours, you couldn't take more than 40 because you can't take anything from overtime hours. So what I said was the FLSA says that a deduction for the employer's benefit for a non-exempt employee is limited to the difference between what they earned and the minimum for up to, but not more than, 40 hours in any given work week. So that's federal standard for non-exempt employees. This afternoon, when I talk about exempt employees, I'm going to tell you that a deduction for the employer's benefit may not be made from the salary of an exempt employee, period, end of conversation. I don't care what the salary is. No deduction for the employer's benefit may be made from the salary of an exempt employee. You make such a deduction, like for cash shortages or damage to the employer's property, damage to the customer's property, et cetera, et cetera. If you make a deduction like that from the salary of an exempt employee, that employee is non-exempt, and you owe them 2 years of back overtime. So it's a giant exposure. Now, you can make deductions from the salary, from the other compensation of exempt employees. So if I'm the store manager of a big store, a Kmart, a Walmart, one of these giant big box stores, and I have a salary of, say, $1,000 a week plus an override, 1% of the net profit, then you can take anything you want out of the net profit, or out of my override, out of my commission, out of my bonus, but you can't touch my salary. Now, this is not a conversation about exempt employees, so that's as much as I'm going to say, but it's important that you have that federal background when we talk about deductions on the state law. So, what we'll find out is, under state law, an employer may not make deductions unless either ordered to do so by a court, like in child support, or unless authorized by state or federal law, such as IRS withholding, or, and this is the one we're talking about, authorized in writing by the employee and then only for a lawful purpose. So, employers may not snatch anything out of an employee's paycheck in Texas, other than legal stuff, without the employee's written consent. But they cannot consent to a deduction that violates the Fair Labor Standards Act. I don't care what they write. If they're authorizing a deduction that would bring them below minimum wage or cut into overtime for non-exempts, that violates the FLSA. If they consent in writing to a deduction that cuts into the salary of an exempt employee, that is an FLSA violation. And under a U.S. Supreme Court case from 1945 called Brooklyn Savings Bank versus O'Neill, employees have no right to waive their rights under the FLSA. No private agreement between employee and employer can waive the rights of employees under the FLSA. That's why when somebody quits and they think they're the victim of discrimination, you can have them sign a release, pay them some money and sign a release, and they've waived their right to sue you for discrimination. But you can't have a release like that for wage and hour violations. It's unenforceable. So, the interplay between the feds and the state is the state permits no deduction without the employee's written consent. The feds the feds don't require permission for deductions, but no permission to violate the statute or the regulations is legal. So does everybody understand the interplay between the state and federal law on deductions? Anybody have any questions on it? Yes, ma'am. I'm sorry, as I said yesterday, I'm getting old and deaf, and I'm going to have to come back and you're going to have to shout at me.
If the employee did sign an agreement whenever he borrowed a loan, he borrowed cash as a loan, he did sign an agreement, he is non-exempt, that can be deducted.
Yes, that was the question was, what if you're trying to recover a loan? And the answer is that's not a deduction for the employer's benefit. The employee has already received a benefit and in fact has, as it were, been prepaid wages, so that deduction is fine. I saw a hand up here. No?
It was the same question, essentially.
Same question? Yeah, that was that discussion I just had was limited to deductions for the employer's benefit. Yes.
Can you give me an example of a deduction that would be for the employer's benefit?
Sure. You issue me a laptop, a company laptop, and I leave it on the airplane, and it gets stolen, and you're mad at me and you'd like to recoup the value of replacing that from my wages. That's a deduction for the employer's benefit. Or I handle cash and my cash register drawer comes up short and you'd like to recover that. Or I drive a company car and I wreck it and you'd like, through my own fault, and you'd like to get the deductible back. Those kinds of things. I saw a hand in the back. I'm sorry, I can't hear you. I'm not following you.
Overpayment.
Oh, an overpayment. Okay. No, the recovery of an overpayment is not a deduction for the employer's benefit. So again, just same as a loan or a cash advance, not a problem. Yes?
Going back to the laptop, to say they terminated and
Yeah.
denied, and when they were hired, they signed that they will return all, laptops.
Mm-hmm.
If they do not, are you allowed to do that?
Nope. Not if it cuts into minimum wage or overtime for a non-exempt or into the salary for an exempt. Against what I was saying. You can't sign an authorization to be paid in violation of the FLSA. You could sign it in blood in front of 40 lawyers and a judge and it wouldn't matter. They cannot consent to be paid less than the minimum wage, less than the amount of overtime they're due, or deducted from their salary. I saw a hand over this way.
I had the exact same question the lady did up there. Just give us more more examples of the
Yeah.
benefit.
Okay, well, again, cash shortages, damage to property, loss of property, maintenance guy loses the keys, and you got to rekey all of the apartments. You know, anything like that's.
Security cards as well.
Security card's a good example. ID, you know, that sort of thing. Now, over here first.
Can you take it out of vacation or sick time?
Yes, you could take it out of vacation or sick time under FLSA. You'd need to, because vacation and sick are generally considered wages under the Payday Law, as we'll discuss in a moment, you'd still have to get their consent. But the FLSA doesn't require vacation or sick, so it would permit a deduction. I will add one little thing. I wouldn't take anything from sick pay of an exempt employee. Because remember, there are certain things, which I'll talk about this afternoon, but there are certain provisions with regard to deductions for absences due to illness for exempt employees that might make that problematic. So don't take it out of sick for exempt people. Yes?
What about uniforms?
Same thing. Uniforms a deduction for the employer's benefit. If they don't return their uniforms, you cannot deduct below minimum wage or cutting into overtime. Yes?
What if the, I guess it's part of the salary, but I'll ask anyway.
I'm sorry, what?
Salaried employee turned in an expense report that ended up, he got his check, it was paid back to him, and then they came back and decided it was disallowed. All the charges were way beyond our policy of what's allowed, and they wanted to take it from his final check.
Question was, what about an exempt employee who turned in expenses? They apparently travel or do some other work on behalf of the employer. They turn in expenses, the expenses are paid to them. Then upon closer examination, it turns out that they're questionable. And the question was, can we deduct that from their salary? I could make an argument, because I'm a lawyer, that's what I'm supposed to do. I could make an argument that if the charges were such that the employee got personal stuff, let's say the guy went out and bought a set of golf clubs on the company credit card, I could make an argument that that's more like an advance of wages or a loan, because what they got was purely personal and they got the value of it. That said, keep in mind what the remedy is for improper salary deductions for exempt employees. It's the loss of exemption. So if that didn't fly, you would get the value of a set of golf clubs and you would pay that employee 2 years worth of back overtime, maybe 3 years, maybe doubled with liquidated damages. I would not risk it. I would not make that deduction from the salary of an exempt employee. Again, I could defend it and I might win, but I might lose, and if I lost, the loss would be big time. So I recommend against it. Yes, ma'am. I'm sorry, what?
How do they view it if it's a terminate, if their last payment and their last paycheck is terminated?
Well, again, and I'm really bleeding over into this afternoon, but when you say they, you're talking about for exempt employees only? Okay. The answer is that for each full work week, regardless of how often you pay, for each full work week the employee works, the employee's supposed to get the full paycheck, subject to the deductions that are permissible in the reg. Now, if the last paycheck covers like 1 week and then half of a next week, you can prorate the salary in the last work week, but the deduction principles remain the same. The deduction principles remain the same. Any other questions on this? Yes, sir.
What about administrative fees allowed by the states for child support? Because that goes directly to the employer, so does that count as a benefit to you?
No, if the administrative fees are permitted by law, then it's okay. Yes.
I'm just curious, how would they determine overtime for an exempt employee if you're not tracking their time?
Well, we're not talking about overtime for exempt employees.
But if you pay them and you risk, I mean, you deduct it, you risk.
Oh, in other words, if there's a loss of exemption, how would they determine the overtime? They'd ask the employee. And surprisingly, the employees worked one heck of a lot of overtime. I saw a hand over here. Yes.
Can a deduction be made from a severance payment?
Can the deduction be made what?
From a severance payment?
A severance payment, yes. Because the FLSA does not require severance pay. Now, if the severance, and we'll see this in a second, if the severance is due under a written plan or policy of the employer, then it's wages, and it's treated under the payday law just like any other wages.
It's usually an agreement that we have to enforce.
Yeah, if they sign it, then it's fine. Because severance is not required by the federal law, so federal law isn't even applicable to that. So then we look to the terms of the payday law, and since severance due under a written plan or policy of the employer is wages, then the employee can agree in writing to a deduction from wages.
But the employee has to agree to
Yes,
the deduction.
yes. Okay, so deductions, always a fruitful and fun exercise. So authorized in writing by the employer, and then only for a lawful purpose. I suppose they can't authorize a payroll deduction to pay for cocaine or hookers or whatever. All right. Okay, now, when a loan is made to an employee, a practice that I heartily discourage, but which you're going to do anyway, authorization to withhold and applicable terms should be established in writing. An advance against wages can count against applicable minimum wage or overtime wages the employer is obligated to pay the employee. So basically, when you're handing money to the employee that they haven't earned, whether through a loan or an advance, then you can use that, then that money is not for the employer's benefit. What this is saying is that if you're going to set up a loan and a repayment, whether you call it an advance against wages or not, you need to go ahead and set it out. Okay, I'm going to loan you $1,000 and you're going to repay it at $100 a paycheck. Signed, Joe Blow, I agree to this. Okay, now, then the employer may not withhold or divert more than the agreed amount. So if it's $100 a week or $100 a paycheck, the employer can't take more than that because that's all that's been authorized in writing by the employee. Yes?
What if you missed one the previous week? You take 200 the next week?
Yeah, I wouldn't have a problem with that.
As long as you're within.
Yeah, yes.
401k loan payments are all the same.
No, this doesn't affect 401k loans. Those operate under their own federal rules. Yes?
What about bonuses or stuff like that? Can the loans that are deducted from bonus?
Are we talking here about a bonus that's like established, like a leasing bonus or something like that?
More like the bonus, the work you do, you get a bonus in percentage on the income that you made for the company.
So this is not a non-discretionary bonus. In other words, we've established what you need to do to earn it. Okay, so then the question is?
Is the loan, can it be deducted from the bonus?
Sure. Again, but lay it out in writing and have the employee sign it. All right. Now, the agreed amount is the amount identified as the amount to be withheld from any one paycheck in the written loan agreement between the employee and the employer or otherwise authorized in writing by the employee for the repayment of the loan. So again, don't make loans without establishing the terms in writing and getting the employee to sign it. Okay, deceased employees. I'm sorry, did you have a question?
On that last topic, so if somebody terminates and have a balance due on that loan, if you put it in the original agreement that, any balance owed would be paid in full
Upon termination.
upon termination, does that apply?
Yeah, that'll work.
Okay.
That'll work. Because again, they've received the money already. So it's not like you owe them wages when they leave because they already have those wages in hand. Now, I would argue that you wouldn't even have to put that in the agreement, that it would just be obvious if the employee quit before they paid it all, that you could deduct the balance. But I'm a lawyer, put it in writing. All right, yes?
What about relocation allowances and sign-on bonuses? If, when you give them to them, you go, you gotta stay this many years or we're gonna get it back, are those allowed to be deducted from exempt?
Under state law, of course, you'd have to get their consent on relocation or sign-in bonuses. There is an opinion letter out there for exempt employees that says that if they are subject to a condition on receiving their salary, i.e. staying with you for 6 months or whatever it may be, that they have not been paid a salary free and clear, and that therefore they are not salaried employees, and therefore they're not exempt employees. So I would not include a requirement like that for an exempt employee. All right. Deceased employees. This is one of those, all right. No, not at all. As I say, we have time. Go.
Opinion letter.
Pardon me?
Where would we go to find that opinion letter?
It's probably too old to appear on the website. You know, DOL has opinion letters on their website, but they only go back to like 2003, something like that. So really what you need to do is use Westlaw or Lexis, if you have access to them. If you don't, then you need to call your handy-dandy lawyer and have him or her research it on the Westlaw or Lexis. Okay, I saw some hands in the back, I thought. Yeah, as I say, you probably have to get it from Westlaw or Lexis, one of the legal research services. Okay, now, this employee, and I'm going to date myself here, like Francisco Franco, is still dead. None of you know what I'm talking about. After the death of Francisco Franco, the dictator in Spain, Saturday Night Live went for months reporting the news and reporting that he remained dead. So during the pendency of that question, this employee remains deceased. You should prepare the final paycheck no later than the final pay deadline and wait until an authorized party shows up to claim it. Okay, let's get real here. It will be very difficult for you when the grieving widow brings the 3 small children in tow down to your office and says, "Give me my deceased husband's last paycheck or my children will go hungry." All right? I mean, we all understand. I'm not trying to make fun of a serious situation, but we all understand that there would be a powerful impetus to go ahead and pay the check of a deceased employee over to his or her family. And virtually every client I've ever had who's been in this situation has done that. Technically speaking, if you do that, and it turns out that this fellow that died had a will, and that will left everything to his dear old mother, then dear old mother or dear old mother's the executor of the estate will appear one day, or can appear one day, and say, "Give me my son Charlie's last paycheck." And you will say, "But I gave it to Charlie's widow." And they will say, "Sorry, at the moment of his death, that check became payable to his estate, and his will says that his entire estate, including that paycheck, went to me. So you're going to have to pony up again and pay me." Now, is that likely to happen? No. Is it impossible that it can happen? No, it ain't impossible. And what happens if Charlie and his spouse were in the last stages of getting a divorce? You know, they hated each other, and Charlie had failed to anticipate his demise and had failed to say to the employer, "In the event of my death, pay someplace else," but it was in his will. Then by paying it over to the not-so-grieving widow, you've made yourself liable to pay twice. I toss it out there for what it's worth. Again, most people are going to go ahead and pay it to the surviving spouse, and it probably won't come back to bite you, but it could. So just be aware of that. Yes?
We changed the
Still goes to their home address.
It's the only address we've got.
Yeah. Well, that's probably going to be fine. But again, what happens if the employee dies on payday? Is in a wreck and dies on payday. And that employee's estate is now the appropriate payee for that paycheck, and that employee's estate leaves the money to somebody other than the person who resides at that address. So there is technically that exposure. I don't know that you can entirely eliminate this exposure. Somebody who dies suddenly, and you may not know their personal situation or family situation. I just want to make you aware of it, that the law technically says that you then wait until someone authorized. And now, if the employee had said had authorized in writing for their spouse to pick it up, I don't think anybody'd have a problem with it. But in the absence of such authorization, then upon the person's death, it's the estate and either the will or the state intestacy statutes that determine the disposition of their assets. Yes?
Would the only penalty be that you would have to make the payment again, or could there be any?
I'm not aware of any additional penalties. Yes?
So would it be good to wait a little bit before you cut that last check?
No, you're supposed to cut the check, as it says up there. You're supposed to prepare it. But technically, you're supposed to hold it until you know who's authorized to receive it and pay it over to who is authorized to receive it.
Okay.
What if it's in process on direct deposit? Should you stop that process for ACH?
I'm sorry, I can't hear you.
What if it's going direct deposit? And if it's in process?
Once it's been deposited timely while the guy's still breathing, then it's payable. Technically speaking, if the person dies before the deposit's made, you should stop the deposit. Again, this is probably more of a theoretical discussion than a practically real discussion, but nonetheless, that's the law. Okay, moving on. How many of you are familiar with the old French term escheat? Yes, that's right, because you're in payroll and you know this. Under state law, unclaimed wages escheat to the state, meaning that they become state property, and if somebody quits you and they have a last paycheck, you've prepared it according to their instructions, and they never claim it, then after 1 year, you're supposed to pay it over to the state of Texas. You contact the Unclaimed Property Division of the State Controller's Office, and they'll tell you how to get rid of it. And they'll take it. Escheat law is fascinating. I don't know much about it, and so I don't get involved with it. But even things like uncashed gift cards and stuff like that are technically subject to escheat to the state if not used. All right. Payments to terminated employees. I guess I should probably change the terminology a little bit since I already mentioned deceased employees. Terminated but not with extreme prejudice, okay? All right. If the employee is laid off, discharged, fired, or otherwise involuntarily separated from employment, the final pay is due within 6 calendar days of discharge. Notice that's not working days, business days, non-holiday days. It's 6 calendar days. So if they normally got their paycheck on the premises, then when you fire them, you have their paycheck available on the premises within 6 calendar days. If you normally mailed it, then you mail it within the 6 calendar days. Whatever their instructions were for delivery, if it's direct deposit, then you direct deposit it within 6 calendar days. Okay. If the employee quits, retires, resigns, or otherwise leaves voluntarily, final pay is due on the next regularly scheduled payday following the effective date of the resignation. So next payday for voluntary, 6 days for involuntary. All right, now, what constitutes final wages? Final wages includes all compensation for employment and vacation, sick leave, severance, or other payments due under a written plan or policy of the employer. And I can't emphasize enough that they mean written plan or policy. So if you have no written vacation plan, you just sort of had a practice of giving them 2 weeks after a year, and they quit after a year but before taking the 2 weeks, TWC will not collect that money because it's not due under a written plan of the employer. Now, the employee may still be able to sue you in small claims court, saying that effectively that was part of the contract of employment, and employment is a contract, even if it's not written. It's a contract terminable at will, with many exceptions, but it's still a contract. So they if there's a severance plan that says, I have an insurance client, they have a written severance plan. If you leave in good terms, then we'll give you a week, a year, or whatever it may be. Then that's part of final wages, and that's enforceable. So essentially, TWC will follow your written plan or policy. Now, they make this clear distinction. I don't know how clear it is. Severance pay is payment by an employer to an employee beyond the employee's wages on termination of employment based on prior service. To be payable under the Payday Law, it must be due under a written plan or policy of the employer. Now, sometimes we get careless about the use of the term severance pay, and we refer to payments made to employees in consideration of their signing a release as severance pay. But for the purposes of the Payday Law, this is what severance pay means. It means that it's payable to them simply based on their prior service. Severance pay does not include payments for liquidated damages, payments in exchange for a release of claims, or payments made because of a lack of notice of separation. What that means is, since that stuff is not severance pay under the Payday Law, TWC can't enforce it, can't collect it. Now, so what that means is, if an employee leaves and that employee has claimed, say, sex discrimination, and I sit down with the employee and say, look, you think you've been the victim of sex discrimination, we think you're a bad employee, you're not happy with us, we're not happy with you, let's get happy. You agree to leave the company and sign this release giving up all claims you have against us, and we in turn will give you a chunk of money. Now, we may call that a severance agreement and release or something like that, but if we, the company, don't pay that severance pay or that release of claims pay, that's not enforceable under the Payday Law. Now, of course, it's enforceable as an agreement, and they can sue you for violating the agreement, or they can say, you didn't pay me the money, I'm now going to sue you for sex discrimination because, you know, my waiver of my right to do so was conditioned upon you paying me the chunk of money. You didn't pay me the chunk of money, I've no longer waived my right, so I'm going after you. Okay. So when employers pay to employees upon termination amounts they are not legally due as consideration for release of claims, this is not severance pay. If the severance pay is due under a written plan or policy of the employer, then such payments to the employee is not consideration for a release. Now, I'll tell you what this is saying. Remember I told you I have a client in the insurance business that has a written policy that says if you leave under good terms, we'll give you a week a year or 2 weeks a year as severance pay. That client could not have that person sign a release of claims based on being paid that severance pay. Why? Because that severance pay was already due to them. And if it's already due to you anyway, it's not consideration for a release. Consideration for a release has to be a payment over and above what you're already due anyway. That's why I can't say, here, sign this release giving up your right to sue me, and I'll give you your last paycheck. Well, it's not operative because I owed you the last paycheck anyway. And I'm not giving you anything more than what I already owed you. All right. Now, I mentioned this before, but commissions or bonuses are earned when the employee has met all the required conditions set forth in the applicable agreement with the employer. And I'm going to tell you a war story with no names, checking my time, that illustrates this perfectly. I have a client. It's a restaurant. They had a fellow who was a catering manager. This catering manager's job, I guess we would call him maybe a special events planner, all right? His job was if you wanted to have a big party, say 20 people, you would contact him and he would get a contract from you, right? Agreeing that you're going to have the wedding rehearsal dinner at this restaurant. And then you and he would agree on the menu, on the wine, on all of the details, what the table decorations would be, all of that stuff. A special wedding cake, you know, whatever it is. And then on the night of the event, and none of this is in writing, by the way, but on the night of the event, he's supposed to show up, make sure everything comes off perfectly, and once everything's rolling, he doesn't have to stay to the end, but he has to be there at the beginning or get somebody else, some other manager to be there. Well, he storms off in a snit and then sues my client in small claims court for not paying him the commissions on several events that were sort of in the process. And our argument to the court is going to be that he did not fulfill all the conditions precedent. On some of them he did have a contract, some he didn't. On some he had a contract and a menu was prepared and everything was done, but he left before the event, which means he couldn't show up the night of the event and ramrod how it was going to go. And so, based on past practice, on a course of dealing between the parties, both with his predecessor, and this is a good argument that we're going to make, when he took over and finished up work in progress by his predecessor, he got those commissions. So that pretty clearly shows that the commissions are only payable when you've done everything, including show up the night of the event. But this is a perfect example of what we're talking about. This is an argument that commissions or bonuses are earned when all the required conditions set forth in the applicable agreement with the employer have been met. They're payable based on routine or practice specified in the agreement when the employee was employed, or on any special agreement made between the employee and the employer upon separation. If there is no specific written policy, TWC will follow the employer's usual practice to determine whether and when commissions are due. Now, in this case, the guy waited way too long. It's 180 days you have to file with TWC, so he's under a contract theory. Okay, and that's that. Thank you very much for your attention. I appreciate it. Thank you. If anybody has any additional questions that they want to ask me, I will be up here and I will answer them. I will answer even the confessional questions, as I said yesterday, the ones that begin, a friend of mine or this company I used to know. All right.